occasionally, something happens that really reminds us of why it is we do what we do. I was preparing to take the deposition or question the owner of a small trucking outfit about his business activities and his business practices that directly led to the death of my client. As part of the preparation, I delved into the new entrant audit standards that a new trucking company is supposed to go through during the first year of its existence, the required policies and procedures for hiring and managing truck drivers, maintaining the trucks, maintaining and reviewing driver applications, company investigations on the hiring of each driver, maintaining driver qualification files, maintaining records of driver logs and receipts to back up those logs, and many other requirements that, when viewed as a whole, create this multi-layered public safety system that's designed to ensure cooperation between employers to identify and weed out unsafe drivers, require drivers to drive only when sober and well rested, and requires drivers to drive only 18-wheelers whose safety systems are regularly inspected and, when necessary, fixed. In preparing, it hit me that I'm part of that safety system as well. When these safety rules are violated and carnage occurs, it's my job to bring into the light how and why this carefully constructed safety system failed, both so the trucking company could see how it must comply with the safety system going forward, and so the jury can see what it will take to make the trucking company comply with these required safety measures and hold the wrongdoers fully accountable for the damage they caused, so that the trucking companies who are doing it right gain a rightful competitive advantage over those fly-by-night operators who regularly endanger all of us. Safe trucking companies and safe truck drivers may not realize it, but lawyers prosecuting these cases keep their industry and the profession from what otherwise would be a mad dash to the bottom. I took the deposition, and the results were just as bad as I've come to expect from many of these first-year operators without any of the multitude of required safety processes or procedures in place. The deposition became as much about educating the owner as to what the rules actually required to be an owner and a driver, what the new entrant audit was all about, and the ways that the company policies, procedures, and processes were a critical part of a safety system. Now, while I don't know what, if anything, this particular owner will take from the experience and use to improve his operation, and while I have my doubts as to whether or not this particular owner cares to fix any of the safety issues, I know that when this case sees a jury, the jury themselves will get an education as to how these regulations make a safety system to keep us all safe, and the rest will be up to them. In the end, I do what I do to educate the jury so the jury is empowered to feel good about their decision to demand industry safety rules and regulations be followed. When prosecuting serious injury cases, like a death from a big rig, if we do our jobs and show the jury how these regulations are designed as a robust safety system, we help ensure those safety systems are followed. When a jury sees that a trucking company is not following those safety rules and could care less if those rules are ever followed, then the jury has the evidence it needs to eliminate that threat to our collective safety. The jury can make sure that the safety-conscious carrier has a competitive advantage over the company that intentionally ignores its safety duties. Now, I tell lawyers all the time that in 18-wheeler collisions, they're not big car wreck cases. Working these cases early often produces evidence of one or more of these required safety systems that's non-functional or non-existent. We do what we do not only to recover money for our clients for their losses, but also to highlight and expose safety problems so that the roads can be made safer for all of us. Maybe you're a lawyer with a busy family or criminal defense practice who has good courtroom experience, but may not have the time or expertise in this type of litigation. Maybe you're a lawyer who works in-house as a corporate counsel or in a non-litigation area of law. Maybe you're a lawyer doing some personal injury work, but simply have not had the experience in dealing with the nuances of big rig litigation that can make a world of difference in the outcome of these cases. If you're a lawyer with an 18-wheeler wreck you need to prosecute, give us a call and see if we would be the right fit for you and for your client. If you or a loved one is harmed in a wreck with a big rig, please call us at 972-854-7900 for a no-obligation evaluation of your case. These cases are normally handled on a contingency fee basis, so there's not a fee if there's not a recovery. To learn more about us, please visit us on our website below or order our free book, Win Your Serious Injury Case, either online or via phone call.